welcome everybody. We are very pleased to be here this morning. We thought it would be a good idea since the Chamber already hosted earlier in this year a webinar on the cross-channel intra-group mobility, but the other way around, so employees coming from the UK to France, and we thought it would be a good idea to do a webinar to explain what are the issues or concerns or things to know when French companies want to send employees, French employees, to the UK. So this is, sorry, it works like that normally. Yeah. So the idea is to talk about the French employees going to the UK to explore or develop the UK market as part of a short-term or longer-term move. So we will not talk about mere business trips, but more short-term or long-term assignments, and wonder what are the key questions to ask in each mobility situation, how French and UK rules can be effectively combined to safeguard employees' rights and optimize the costs for the company, because as you will see, an assignment to the UK can be quite expensive. So we will talk about immigration, employment law, should we stick to a French contract or go for a local contract? We'll talk about social security, obviously, should it be a secondment or a local affiliation, and talk about tax, individual taxation and corporate tax issues with permanent establishment risk. But first, as Catherine told you, I am Stéphanie Lemaine from Galahad in Paris. Galahad is a French niche firm dedicated to compensation and benefits and global mobility that we created 10 years ago with my partner, Nicolas Pregliasco. We assist our clients in managing all types of issues related to global compensation strategies and management of mobile employees. We cover employment tax, international social security, but also the parts of employment law, corporate law, and corporate tax law that are linked to compensation issues and global mobility of employees. We are the proud French member of the CELIA Alliance for Tax and Comp and Bens. CELIA is an alliance of law firms that was created by our partner in the UK, Abbiss Cadres, and I will let Zangir from Abbiss Cadres introduce himself, and potentially Jonathan if he joined us in the meantime.
Thank you, Stephanie. Yeah, Jonathan is slightly delayed, but he'll be joining in a minute. So my name is Zangir. I'm a tax director at Abbiss Cadres. As Stephanie has said, we are a co-founding member of the CELIA Alliance of law firms and professional services firms, which is an alliance focused on tax and comp and bens, as Stephanie said. Abbiss Cadres is a London-based professional services firm. We are proud to be multidisciplinary, and we focus on all areas around employment, specifically within employment law, tax, HR, immigration, and our core strength lies within things like global mobility and cross-border people solutions, which is what the webinar is about today, of course. And thank you for welcoming us to the call.
So what should we do? Because Jonathan was supposed to start with immigration, so maybe we should jump to employment, social security and tax, and then we'll do immigration at the end when he arrives. Let's do that.
Agreed.
So, sorry, I will go faster on immigration and here. So starting with employment law. Well, actually, French companies sending employees to the UK will merely have two solutions. Either they will keep them under a French employment contract, in which case the employee will be posted to the UK by the French company, and more likely placed at disposal of the UK entity of the group, if any. So we, as I said earlier, we will focus on French companies sending employees to develop or explore the UK market. So obviously, if there's already a subsidiary, the idea is that the employee will be working for this subsidiary. So if the French contract is maintained, then it means that the French company will have to enter into an agreement with the UK company so that it would loan its employee to the UK company. The second solution is to provide the employee with a local contract with the local subsidiary of the group, in which case the contract will be subject to UK law. So as I mentioned, if the employee remains under a French contract but works for the benefit of the UK entity, it falls within the scope of the loan of employee under French employment law, meaning that the French employer will have to sign an addendum to the employee's employment contract, but also an agreement with the UK company, providing for a full recharge of the cost linked to the employee, including employer's portion of social security contribution, gross salary, and any other compensation item and professional expenses. But it should be recharged without margin. This is very important to know for a UK company, because this is consistent with French law that prohibits a for-profit loan of employee. It means that the French company cannot make any profit while lending his employee to the UK company. This is a very important provision because any breach of these provisions is criminally sanctioned in France. The other solution, as I mentioned, is a local contract that would be entered with the UK entity. And in this situation, the French contract could be either suspended or transferred to the UK company. So obviously, each solution has its pros and cons. Keeping a French contract may seem simpler at the beginning, more particularly if there's no HR structure in the local subsidiary, and it more particularly also allows to avoid two termination procedures with different motive, obviously, in case the contractual relationship with the employee would cease at the initiative of the employers. But this solution is generally linked to the wish of the company to second the employee from a social security standpoint, which we will see is hardly a good idea with the UK. So a local contract may be easier when the local social security system applies, and it's more consistent also in case of a longer assignment. So if the employee, sorry, it doesn't work. Yeah. Sorry. So Zengir, if the employee works in the UK, what are the principles that will apply?
Yeah, absolutely. So on the UK side, UK employment law will apply for a French employee on assignment in the UK or on a local contract. What that generally means is that the assignment letter, if they're on assignment, should be in line with the UK employment law requirements, or if they're on the second approach, the contract approach, the contract has to be in line with the UK employment law requirements. Kind of on a more general level in terms of employment law, like in the EU, the UK employees will be entitled to protection, local kind of mandatory laws in terms of rights given to them in the employment contract or the assignment letter, and the this kind of will act as a kind of a local layer of basic employment rights in terms of protection against dismissal and discrimination. So, as you know, most jurisdictions will probably prohibit things like workplace discrimination. So in the same way, in the UK, there's going to be a range of characteristics which will have protection in terms of differential or adverse treatment. And then, like in some countries, in the UK, there's some positive obligations to take active steps in terms of, for example, assisting disabled employees. And just like in most countries in the UK, there is a form of protection against dismissal. So in the UK, like in the EU, that's a relatively sophisticated system, generally relying on the employee needing to be employed for a specific period of time before they qualify for the full dismissal protection.
Okay, thank you very much. Just one additional comment. If, as from you said, if the French contract is maintained, I assume that there will be no issue because normally French law is rather protective of the employees. So this should not be an issue. That could also be something that French employees would rather have than a UK employment contract. So that may come into the discussion. But as far as protection against dismissal is concerned, as I mentioned, if the French contract is suspended during the local UK employment contract, it means that in case of termination of the UK contract, the employee automatically comes back on his French contract and may benefit from also the French dismissal, protection against dismissal. So in this situation, we can manage to reassure the employee about his protection. So as far as social security is concerned, in principle, as you may know, an employee is affiliated to the social security system of the country in which he or she performs his or her activity. By exception, and this is true not only within the EU, but also in other countries with which France has signed totalization agreements, it is possible to maintain an employee to the social security system of his or home country, in our case, France, within the scope of a secondment. So it should be noted that post-Brexit, the social security coordination rules between the EU and the UK are now provided by the social security protocol to the trade agreement between the EU and the UK. And these provisions are very similar to the rules of the EU regulation that we usually know within the EU and that were applicable before the Brexit. So it means that the secondment is also possible under the new rules of the Social Security Protocol. So it means that two solutions are possible. Either a secondment where the employee remains covered by the French social security system, which is only possible if the employee remains employed by the French company and if the secondment is provided for 24 months maximum, or an affiliation to the local social security system, which is called an expatriation under French social security law, which could be completed if necessary by an affiliation to the French social security system on a voluntary basis. So in case of a secondment, all French contributions continue to apply, except for CSG and CRDS, which are only due if the employee is a French tax resident. So generally speaking, as we will see later, the assignee transfer his tax residence to the UK. So these contributions will no longer apply. And in this case, the assignee is subject to a special 5.5 health insurance contribution. But in this case, although it may seem simpler, it should be noted that complementary health and welfare insurances generally have to be adapted to be extended to secondees, so employees not working in France, because generally these contracts, which are private insurance contracts, cover secondees only for a very limited period of time, and the extension will also obviously have to take into account the fact that they will not be working in France. So in case of affiliation to the UK social security system, most French employees will ask for an additional coverage to keep the link with the French social security coverage. It is done through the Caisse des Français de l'étranger for the basic coverage and with Humanis for complementary pension, and also with private insurance companies for complementary health and welfare insurance. So what are the pros and cons of each solution? Secondment may seem simple, and it's generally a solution that French companies like for let's say short-term assignments. It is simple. The payroll administration is the same as the ones French companies know, but it is actually very expensive, meaning that every additional compensation item that you would put in the package of the assignee will have to be subject to French Social Security contributions. And the main point with respect to the UK is that from a tax standpoint, and Zangir will explain it later, personal income tax is calculated on the gross income. So it means that Social Security contributions, even compulsory ones, are not deductible for tax purposes in the UK. It means that the combination between French Social Security contributions and UK personal income tax calculation is really not a good combination, as it is very expensive. It means that for the company, if they want to maintain a certain level of net salary for the employee, and as we'll see, make a calculation of tax equalization or tax protection, it will become extremely expensive to keep the employee under the French Social Security system. So the expatriation is actually cheaper. UK Social Security contributions are much lower than French contributions. And if we want to add a French Social Security coverage on a voluntary basis, it means that we can choose the reference salary on which are calculated such voluntary contributions. So, for example, it's not compulsory to contribute on the school fees, for example, that the company would agree to pay to the assignee. What is true also is that expatriation is much more complicated from an administrative standpoint, more particularly if the French contract is maintained, because it means that there's a need to set up a local payroll in addition to the French payroll, so a shadow payroll plus the French payroll, and to enter into all the affiliation formalities to provide additional coverage on a voluntary basis. It is, however, generally what we advise to our clients because of the cost of the secondment solution. So, Zangir, if you want to talk to us about the tax in the UK for the employee.
Thank you very much. Yes, so on the tax side, of course, it's important for both the employer and the employer to understand where income tax is payable in relation to that individual's income. As a starting point, all jurisdictions will tax or impose income tax on the worldwide income and gains if an employee is a tax resident in that country. And when I say all, there's a few exceptions, but almost all countries do that. And it's the same in the UK. For example, if an individual is a UK tax resident, they would be liable to income tax in the UK on their worldwide income. Now, in the same way, almost all jurisdictions will impose income tax on any income arising in their respective jurisdictions, regardless of the resident status of the individual. So in this example, if an individual is a non-resident in the UK, but is, for example, working from the UK will impose income tax in relation to the work days in the UK. It is kind of relatively normal for countries to seek to tax employees from the first workday in that country, depending on certain exemptions and depending on whether the tax treaty between the two countries may apply. But the other consideration here is the administrative one, because as a general rule, if the employee has taxable income, which did not have tax withheld at source, that probably means that the tax return filing registration would be required in the UK. So, for example, employment income, as we all know, is typically withheld at source through payroll. But you may, for example, receive rental income from a tenant, which is not withheld at source. And the tax return in the UK serves as a final declaration and reconciliation of any taxes due for the tax year. And as you know, the UK has or as you may know, the UK has a slightly unusual tax year, which runs from the 6th of April to the 5th of April. And of course, that's also an important point to consider, because Most countries run a calendar year tax year, so 1st of January to the 31st of December. So it's important to ensure that any period of the secondment or the expatriation is properly accounted for in terms of tax returns in the UK and correspondingly most likely in France as well.
Yeah.
Now, the other thing to mention here is that we talk about the employment income aspect here, but also there's personal income, which may be impacted by the cross-border work in a similar way. However, as we will find later in the presentation, actually the core principles which I've mentioned around residence and whether the UK taxes a UK resident on their worldwide income or not also depends on whether a special tax regime is available to the individual or not. So next we have the statutory residence test. So this is the way in the UK we determine whether somebody becomes a UK tax resident or not. So as I said, it's important to understand that because of the understanding the scope of tax that the UK will impose on the individual. So this applies, as it says on the slide, to both income tax and capital gains tax and applies on an annual basis. So the result of the tests will determine whether an individual is a UK tax resident for a specific year under the UK tax rules. But should they be a resident in another country, France in this example, we would also need to refer to the tax treaty between the two countries to determine whether they're resident, where they're resident for any given period of time. The way the test works, I think that's on the next slide, is basically split in 3 parts. So first, we would determine in the UK whether the individual coming into the UK from France in this example remains non-resident in the UK. If they don't meet this automatic non-residence test, which is the first arrow on the slide, we would then check whether they've become automatically resident in the UK based on a set of tests. And then if they don't meet either of those, we would go to a sufficient ties test, which is essentially a tiebreaker test, which would set a threshold of the number of days above which the individual will be a tax resident in the UK. But if they're below the number of days set by the test, then they wouldn't be a UK tax resident. So just very quickly to give you an overview, for the automatic non-residence tests, we are looking at essentially a threshold of either 16 or 46 midnights or days in the UK, or the employee has to be working full-time overseas. So essentially, this is very unlikely to be met by somebody coming into the UK for work, which means we have to check the automatic UK tests. So the next slide, yeah. So the automatic residence tests that can make somebody a UK tax resident are either if somebody spends 183 days in the UK, which may be familiar to anyone working with other countries' tests about residence, or if they have a UK home for a period of 90 days and are present in it for at least 30 days. And the criteria here is actually caveated with not having a home overseas at the same time. So it's possible that if an individual retained their French home and hasn't rented it out, for example, that they wouldn't meet this test. But if they have rented out the French home, they would likely meet this test and become a UK tax resident. And the third criteria is that they work for sufficient hours in the UK over a 365-day period. So this is essentially 75% of their work time without taking any breaks of more than 30 days.
Sorry. Oopla, sorry.
Oh, yeah.
Yeah, I'm back.
So, yeah, perfect. And this next sufficient ties test is more likely to apply if somebody doesn't meet the previous 3 tests we mentioned. So somebody coming into the UK for a period of roughly 6 months or more, or working in the UK for a full year, or somebody who's rented out their house in France or doesn't have a house available in France anymore, they will likely meet the automatic tests I've mentioned earlier, the UK ones. But otherwise, we would probably have to check the number of ties they have to the UK. And as you can see, there are 5 possible ties, whether they have a family in the UK, whether they have an accommodation, and this is kind of set more as, hotels or rental property, or could be a property that they own in the UK, whether they work for 40 days or more in the tax year, and how much time they've spent in the UK historically, and which country they spend most time in. So based on the number of ties, the threshold would be set. So, for example, for somebody who's coming into the UK for the first time, haven't been a tax resident in the UK in the past, let's say they have 1 tie, then the threshold would be 183 days. If they have 2 ties, it would be 120 days. 3 ties, 90. 4 ties, 46 days. So as you see, the threshold is lower the more ties they have to the UK, because that means effectively, the ties make it more likely that they become a UK tax resident with fewer days spent in the UK.
Okay.
So the likely outcomes, as I said, are that if a French employee works in the UK for 6 months or more, they're most likely going to be a UK tax resident. If they're less than 6 months, it's possible that they would be a UK non-resident, but we'd have to look at those ties that I've just mentioned. Theoretically, that means that the UK resident French employee will pay tax in the UK on their worldwide income. But as I said, there's also a special regime available in the UK.
Yeah, if I may, Zangir, there are situations that we see a lot now where the employee goes to work in the UK for a UK company, but the family stays in France. And in these types of situation, although it needs a deeper analysis, obviously, of each person and each situation, we tend to think that the tax residence remains in France. But it's very important also for companies to be aware of the situation of the family during the assignment to the UK, to be able to determine where the tax residence will be during the assignment, because these are very personal criteria, as we saw under UK domestic law, but it is also true under French law and pursuant to the tax treaty between France and the UK. So these are facts that really need to be known by the employer to determine the tax residence of the employee. So special tax regime in the UK.
So the special regime in the UK is allowing new arrivals to the UK who haven't lived in the UK or were non-resident in the UK for the previous 10 tax years, regardless of their country of origin, to not pay any tax on their non-UK income and gains for the first 4 tax years of residence. In the same way, they would also be able to exclude any overseas workdays, so non-UK workdays, from UK taxation for those first 4 tax years. If you have followed the kind of the news in the UK, this regime was historically known as the non-domicile regime, but it has been reformed last year. So effectively what this means is that there's no need to, for example, retain any income outside of the UK or ensure that the individual's country of origin is looked into. So as I say, it's relatively straightforward nowadays. We just look at whether they've been non-resident for the previous 10 tax years. And if that's the case, they are exempt from foreign income and gains for the first 4 tax years of residence. So what that means is that, for example, if somebody has a French rental property whilst they've started their UK expatriation or secondment, that French property would not be taxable in the UK for the first 4 tax years of residence even if the individual is a UK tax resident. And in the same way, if the individual spends, let's say, 30% of their time in France working, then only 70% of their employment income would be liable to UK tax. But there is a cap on the overseas workday relief. So the relief relating to the overseas workdays of £300,000 or 30%, which is why I've used that number in my example. And then another special rule in the UK in relation to expatriates or secondees is that if an individual comes into the UK with an intention of staying here for 24 months or less, the special rule around travel and accommodation costs allows them to exempt those costs from UK taxation, which could be, of course, a significant saving. Because, for example, if the company provides an employee with a rental accommodation in the UK for the duration of their stay, the first 24 months of that benefit would be exempt. However, this is also contingent on the UK being a temporary workplace. So this is more applicable for individuals who have an assignment letter and a stated intent of returning back to their home country, to France in this example, within the 24 months of the assignment. So whilst it might be beneficial in some forms for to take a longer contract or switch to a UK contract, from this rules perspective, the assignment approach perhaps is more beneficial. But again, it's important to remember that the relief applies to the individual. If they're coming in with their family, then it would be restricted to only account for the individual's portion of the accommodation and travel. And next,
Yeah.
we have tax equalization, I believe.
Yeah, well, that was the comment following on what I mentioned earlier, meaning that the UK tax is, as you said, calculated on gross income, which is a very big difference of system as from the French one, where we have a possibility of deducting, 90% of the social security contributions of the employees' portion of social security contributions from the taxable income of the employee. So it is true that UK tax rates are rather high, and for families, for example, generally the tax is much higher than the French one, because in France we have this system of family ratio that allows employees to reduce the cost of their personal income tax. So what has to be taken into account is that in case of voluntary coverage in France for social security purposes that would be paid by the employer, such costs, such contributions are considered taxable benefit in the hands of the employee. So it means that at the end of the day, it's very likely that the UK tax that will be payable by the employee during the assignment will be much higher than what he would have paid in France, and the net salary of the employee would be lower than what he would have had if he would have remained in France. So the employer may end up with an obligation, or at least a strong incentive to tax equalize or tax protect the employee when during the assignment, if he wants the employee to move to the UK. So everything has to be taken into consideration, and the special tax regimes that Denguir explained are obviously something to be used by French companies to build their tax equalization, so that they would try and reduce the cost of this assignment. So yeah, that could be either defined in the agreement or that could be in the global mobility policy of the group or of the company. This has to be carefully structured to clear, because this is not a legal provision. This is purely contractual. So it means that the company has to be very clear on what they take into account in the, let's say, hypothetical tax that they would calculate if they want to protect the employee against a higher tax in the host country, and more particularly in the UK, and clarify that they will, for example, only take into account professional income and no other personal income, that which size of family they will calculate the French hypothetical tax on, etc., etc. So these have to be provided in advance, in agreement with the employee, so that everything would be clear and that the employee will agree to be withheld from an amount of tax that corresponds to what he would have paid if he would have remained in France, whereas the employer pays for the global amount of tax paid locally. So essentially, this is indeed an entitlement for the employee to receive a net amount, either a net minimum amount or a net fixed amount that corresponds to what he would have had if he would have remained in France. Zangir, do you want to talk to us about the PE risk in the UK for French companies?
Sure. So this is more consideration, of course, for the employer from a corporation tax perspective. So just very briefly, corporation tax is paid by companies on their profit, and it's paid where the company is registered or incorporated or listed, or where it has a permanent establishment. And permanent establishment historically was an easier concept to define because essentially it would be, a footprint in a company such as an office or some sort of facility. It's a little bit more complex now with remote work. But of course, the key question to consider here is whether the French employee's presence in the UK can cause the French company, the employing French company, to have a permanent establishment in the UK, meaning that the French entity now has to file a tax return and possibly pay taxes in the UK. The risk is mitigated by having an entity in the UK to which the French entity seconds or expatriates the employee. So effectively what you do is you ring fence and split the corporation tax by country neatly, because you allocate the costs similar to what we discussed, I think, at the very beginning of the webinar. But it may be more of an issue for cases where, a French company has very, very few employees in the UK, say one, it doesn't have an entity in the UK. And that's where the permanent establishment risk may be triggered depending on the activities of the employee in that country, or the amount of time the employee spends in that country. So very broadly, the way permanent establishment can be created is, for example, if an employee has an authority to conclude or negotiate contracts, if they exceed roughly the 6-month mark in the UK, but also if there's a fixed place of business, such as an office, for example, that exists in the UK. So it's definitely an area to look into if, in particular, the French entity does not have any presence in the UK in terms of corporate legal entity.
Yeah, definitely. And it's also the case, although it's more rare, if they have an entity, but the employee actually does not work for the benefit of this entity, but is merely hosted by it. But it's, well, more complicated, but it really can happen. So it's something to look into. I think we have Jonathan with us, who will be able to talk to us about the immigration issue. Hi, Jonathan.
Good morning. Sorry I was
Good
late, and
morning.
sorry I'm a little bit off brand, but
Yeah. Don't worry. So we'll go back to the beginning of the webinar and let you talk to us about immigration for sending employees to the UK.
Brilliant. Thank you very much. Well, it's lovely to be here, and I'll give you a slightly whistle-stop tour because obviously time is limited. But in terms of what we provide, we offer a full scope of immigration services. We focus on helping businesses send their workers to the UK or UK businesses hiring. But we can also do individuals and help with families as well. But yes, if I could go on to the next slide. So today we are going to particularly looking at French companies who have a presence in the UK and where they want to bring some French employees over there, or where they don't quite have the business set up but want to do that. In that, we'll look at the way in which that's done, the process, how long it takes, and also what the costs are, because as Zangir was saying, as well as there potentially being tax issues with sending people here, the UK Home Office is definitely increasing costs. So that's something that always needs to be considered, because costs raise fairly regularly. I'm not going to be considering visit visas. Obviously, there are certain things that individuals can do as on a business visit, and as French citizens, you're not required to obtain a visit visa. But obviously, we'd be happy to assist in advising on what you think you might be able to do as a visitor. But realistically, what we're looking at are employees who are going to be coming for, say, at least 6 months. In general, for an overseas worker to come and work in the UK, they need to be sponsored by a business that's already here. That company needs to obtain a sponsor license. And there are many different types of sponsor licenses, but I think those which would be particularly of relevance for this audience would be skilled workers. So those are people who can be new to the business. They don't have to have a history of working for them in France. And that's done just on the basis of showing that they're the best person for the job. Then the global business mobility routes for senior and specialist workers, or other people who might be graduates on a graduate scheme, or some of the other ways in which people might want to be sent to the UK are covered by that sort of license. But there are other sorts of license as well. But time will mean that we won't go into too much of that. So the scale-up worker, that's for companies who are growing very fast in the UK. You have to show over a couple of years a certain amount of growth. And if you have that, then you're allowed to bring in quite a large number of workers to help you with that growth. The graduate trainees, that's if you've got a graduate program within your business overseas, you can bring those to the UK as part of their development and their education, and getting them involved in the business. Service suppliers, that's where you have a contract with a UK company, and then you can, obviously you're not linked to the company there other than by the service agreement, but you can send workers over for 6 or 12 months. And then secondments for individuals who are coming from overseas to work as part of a high value contract. But those are probably the main types of license that you would be interested in. If the business isn't yet operational in the UK, you can get what's called the Global Business Mobility route on your sponsor license. For this to happen, the company does have to have a footprint in the UK, and that's either done by securing an office or by registering with Companies House. So in respect of Zangir's last point about the permanent establishment risk, there may not be many situations where, in fact, there is only one worker who's here without having some sort of permanent establishment. Certainly, companies, to get a sponsor license, need to show that they are established here, and so that may not be such an issue. It may mean that obviously, as Zangir said, you have to find ways of ring fencing the workers who are in the UK so that you don't expose the company to the risk of corporation tax. But if we move on then to the process of obtaining the sponsor license, it's an online application process. For those of you who've done it, you know how outdated it is and how unsuitable to I think probably the 20th century, let alone the 21st century. But it is what we have to deal with, and obviously a lot of the language used doesn't really fit with modern working situations. But we're happy to help advise on what those choices are, where you've got to deal with some outdated language and trying to fit that into what the modern working situation is. For the license to work, you have to have individuals who will run the license for the company in the UK. So they have to be UK-based employees. So the only exception is where you're wanting to expand into the UK, then you don't need any UK-based employees. But otherwise, you do need someone in the UK office who's able to run the license, to be high up in HR, to be the person who's responsible for making decisions on new hires, and then people who are also responsible for running the online sponsor management system. Obviously, in small organizations, that can be the same person. You generally have to show 4 pieces of evidence to show that you are an established company in the UK, and that can range from things like your business premises lease, your bank account, various tax documents, other contracts you might have to show that you're trading in the UK. As I say, because of the slightly antiquated online application process, it can be a little bit laborious getting all of the required information. But if there is urgency, it can be done pretty quickly. But generally, we would expect to be able to get the application up and running and submitted within 2 or 3 weeks. Once it's been submitted, the standard processing time is 8 weeks, but you can pay for priority processing to get the decision within 2 weeks. Once you've got the sponsor license, you then can give certificates of sponsorship to the individual workers. Each worker needs their own individual certificate. For both the skilled workers who are already in the UK and for the global business mobility workers who are not in the UK, when you're applying for the license, you can ask for those certificates of sponsorship in advance. If you're wanting skilled workers who are currently overseas, you need to apply for those on an individual basis. But again, that's relatively streamlined, so you should be able to have the certificates available relatively quickly. Once you have the certificate, you assign it to the worker. They then make the online application. They may need to provide supporting evidence. So, for example, French citizens do need to establish that they can meet the English language requirement. In addition, they may have to provide financial evidence, but businesses can certify maintenance on the applications so that they don't have to. For European citizens, the application process is somewhat streamlined. It used to be the case that you had to attend biometric interviews to show your passport and have your picture taken. That can now be done on an app, and French citizens are certainly able to take advantage of that. Again, for applications made overseas, it's a 3-week standard processing time from the date the application is submitted. But again, priority processing is usually available to get a decision within a week. And then if we move on to the costs, so these are costs that are correct as at today's date. There are some increases that are coming to the immigration skills charge later this month. So certainly it's always wise to get the latest information so that the amounts that you're expecting are the amounts that you'll actually pay. So for small companies, and that's a company that employs up to 50 people or has a turnover up to 10 million within the UK, not looking at the global business, they would qualify for the lower costs for both the sponsor license application and the immigration skills charge. Everything else really is dependent on the length of the visa. So the visa application fee varies if it's a visa up to 3 years or over 3 years. The immigration skills charge and the immigration health surcharge are both annual fees which are paid for upfront. For family members, obviously, if you're coming for an extended period of time, you may want to bring the family as well. Families can be included in the applications, and they only pay the application fee and the immigration health surcharge. You don't need certificates of sponsorship for each family member. The visa costs are the same. The health surcharge is slightly lower for children. It's currently £760. But those are the costs. So if you're sending a number of employees, obviously those costs can rack up quite quickly. So it's always important to bear that in mind. And then finally, if we look at what the main differences, if we go to the next slide, please, Stephanie.
Yeah, I just had a question regarding the immigration health surcharge. It applies notwithstanding which social security system will apply to the employee. It's just
absolutely.
It's due.
Everyone has to pay it. It entitles you to use the NHS, even if you've got other agreements that would allow you to, as a visitor, to use the NHS. It's just another way that the Home Office makes it more expensive to disincentivize people from coming.
Thank you.
So the main difference between the skilled worker route and the global business mobility route is that on currently the skilled worker route, you can stay permanently within the UK after 5 years. On the global business mobility route, you can never get settlement if you're just using that route. The plus side for the global business mobility route is obviously there are some slightly lesser requirements. So, for example, you don't need to have satisfy the English language requirement on the global business mobility route. And also the Home Office are likely to be less interested in any recruitment process. If someone's been working for you, they're happy for you to send that person. You don't have to show that there's someone within the UK who would have been able to do the job just as well. So I think that's a whistle-stop tour of sponsor licenses and using those to get French workers into the UK for your businesses. And I think we're now happy to take any other questions.
Yes, thank you very much, Jonathan.